Hi, today we talk about strategic intellectual property management for startup founders. So, there are a number of topics here to help you move along and make your process smoother. So, first, time your patent filing strategically. File before any public disclosure to preserve international rights. In the US, you got a 1 year grace period, but that is not true overseas. And so, if you want patent protection in Europe, file your patent before you disclose it publicly or you offer them for sale. Second, consider filing provisional patent applications to secure early priority dates. These are simple to do and inexpensive. You can visit us at Patent PC and we can do that for $1,800. Balance early filing with a well-developed invention. So it's important to get an early filing, but also have a well-developed invention in the early filing. So you should find a certain point where your invention have matured enough that you can file them early, but yet you have enough details so that it will be defendable. So, for example, what you can do is the first idea that you have in your business, you may have an idea for a flying car, but filing that early, you won't have enough details to defend your patent against obviousness or anticipation issues, right? So if you want to get an early filing, that what you do is you sit down, you brainstorm about all possible implementations of that flying car, and then you file them, even though you may not have a specific direction yet. Having enough detail in your application will help you navigate around known prior art because your technique might be different from others. So I will do that first. And then let's say 6 months therefrom, once you have more specificity in your invention disclosure, you can convert that provisional into a non-provisional. And so that's how you balance the early filing date with having a well-developed invention. You can also align your patent filings with your product development and business timelines. So, for example, before you talk to investors, you should file some provisional applications to protect your basic idea because investors will not sign NDAs, right? Then, as you have your team on board and you develop an early MVP, you should consider filing at the MVP stage because that's the first time that your product has come into life. Then, once you've done your MVP phase and you decide that there's certain features you're going to have and then certain features you're going to cut out from your final product, that's time again to consider patenting. Then, of course, most companies on an annual basis have a new release. That's yet another point for aligning your patent filing with your product development and your business timeline. So, the last point we want to make here is that use the 1 year grace period in the US strategically if needed, but don't rely on that because if you want to go international, that the information that you release in that 1 year grace period prior to the US filing will not help you internationally because whatever you make publicly available, it's also prior art outside of the US. Next, we talk about cost-effective IP protection. So, for cost-effective IP protection, you should prioritize protecting the core technologies and protecting your core competitive advantages. That allows you to have a very tight focus on where you're going to spend your resources. That allows you to focus your decisions on how to spend your valuable resources on key technology and competitive advantages. You also might want to consider filing a provisional patent application to defer the costs. Provisional applications can be done simply and can be done with automated tools such as PowerPatent. And if you provide detailed information in the provisional application, you can get that early priority date, and then a year from then you can bring that to a lawyer and they'll professionalize it, and you would defer your cost for that year period. You should also leverage online resources for preliminary searches. The Patent Office has a great search tool. There are others such as the Google Patents. You should also educate employees on IP protection to reduce the risk. You should train them that, hey, every You should train them not to disclose information about their work to other people, because that disclosure may inadvertently create prior art against your subsequent patent application. You should also train them before they publish, run any kind of professional publication through you to see if they should be patented by ways of a provisional application, for example, before they publish. And that should reduce the risk of you in not able to patent their work. You should also train them on trade secret issues, because part of the requirement for a trade secret is that you take efforts to protect your secret. And so if you train them on trade secret, you sensitize them on what not to disclose to other people. And even in the situation where they leave the company, they'll be sensitive to the fact that there's certain information you consider to be trade secret, and they should never disclose it to anybody or use that for their own benefits. You should also conduct regular IP audits to optimize your patent portfolio. So the audits should cover your patents, your branding or your trademark rights, your copyrights in, let's say, your manuals and your website and brochures, and also your trade secret, whether or not you've taken enough care to protect the items that you view should be designated as a trade secret. Now let's talk about IP considerations for outsourced development. First, you should use a very strong non-disclosure agreement, or NDAs, or confidentiality agreement with contractors. You should clearly define the IP ownership clause of the contract, that anybody that you pay money to, whatever they develop, the IP belongs to you as a company. If you're silent on this, the contractor can assert ownership of the IP. And that is certainly the case for copyright. So if you hired a contractor to develop your website and you didn't have a clause that you own the site, all you would have is a license to be able to run the website, but the ownership of the content actually belongs to the contractor. Similarly, in patent issues, if you don't have clarity in IP ownership, the contractor would say that it's their ownership. Consider geographic separation of the engineering teams. So if you're going to disclose some vital solutions to your product, you might want to consider 1/3 of the design in outsourcing it out to, let's say, to one country, and then 1/2 to another country, and then you retain the remaining component, the core component, when you integrate them together. That way, when the subcontractors, when you no longer work with these contractors, they won't know enough about your entire product line to be able to re-implement your invention and then sell it in their countries. You should implement security measures to protect the trade secrets. Obviously, for a trade secret, you should release as little as possible and under a very tight NDA to prevent the trade secret from leaking out to other people. In general, don't release trade secrets if possible, but if you have to, make sure that it's under a very tight NDA. You should also periodically conduct due diligence on your outsourcing partners to make sure that they aren't taking your ideas and using it for their own internal use or for other clients. There are reports that, in the manufacturing side, some companies have produce extra parts so that they'll sell those extra parts as gray market sales and make extra money that way. So having a due diligence on your partners will control that risk. Now let's talk about the IP development timeline. You should start with a provisional application for early protection. Now, for full use of a provisional application, you should write them in as much detail and as much care as a non-provisional, but you file them as a provisional. That way, you get full protection and an extra year of life, because in a non-provisional, the life starts from the time of filing. So if you start at a provisional and then in a year's time, you convert that to a non-provisional, what happened is you would have effectively 21 years of life when you stack their life together. And that's the optimum way, and that's how the pharmaceutical companies do that, because every extra year is worth billions to them. Right? So The key here is you start with a provisional application, but you must file the non-provisional within 12 months, or you lose that date of the provisional. And then if you've sold products during that time, and if you can't claim your priority date back to the date of the provisional, your own product could possibly be prior art against your non-provisional application in that scenario. So make sure you file non-provisional patent applications within the 12-month period. Now, we talk about the conversion within 12 months from a provisional to a non-provisional. The same rule applies to international application. So you need to file for international application within that 1 year period from the provisional. And at that time, you also must decide international filing. So the way most startup companies do this is they use the patent cooperation treaty during that 1 year. So a patent cooperation treaty is a single application that is good for most major industrial country of the world. And the effect of the PCT application is to extend the deadline for going into each of those national country by 30 to 31 months from the earliest priority. So what does this mean? You file your provisional in 12 months, you file your non-provisional and your PCT, and that PCT extends your deadline out by at least another 18 months from that 1 year filing. Because when you tacked in the 12 month of the provisional plus the 18 month, that's the 30-month deadline for the PCT national conversion. You need to also budget the maintenance fees throughout the patent life cycle. So when a patent issues, every 4 years, you got to pay a maintenance fee. And the fees go up over time because the patent office assumes that if you want to keep the patents for a longer duration, those patents must be valuable. So you need to plan for those fees. And if you have a large portfolio, those maintenance fees can eat up a significant chunk of resource. So in those situations, you want to regularly review and prune your portfolio as your technologies evolve. And you can prune it by a number of ways. Preferably, you should go and find licensees for patent that you're no longer interested in, because that way the licensee pays for all the costs and you make money from the licensing. You can also sell the patent outright. And then, of course, if you can't sell and you can't license and the technology is in a field that nobody's interested in, another option is to just simply abandon those patents and focus your money on new technologies, on the cost of patenting new technologies. So now let's talk about international patent protection. So first of all, you need to understand that patents and IP rights are territorial in nature. So if you apply for the US patent, it only covers the US. If you apply for a European patent application, it only covers Europe or the specific countries that you've designated in the European patent application. Or in Japan, same thing, right? So it's territorial. And if you want rights in these countries, you need to think about them in advance. By law, you have 1 year from a US filing to file internationally, and you will still be entitled to get the US filing date. This has to be done within 12 months of the US filing, the first US filing. Now, because most companies at the end of the 1 year period, they don't have a clear idea of which countries they need to go into for commercialization, you can leverage what is known as the Paris Convention for Priority Claim. So it's called a PCT. And a PCT, what you do is at the end of that 1 year period, you pay one single fee, roughly around $3,000 to $4,000 to the WIPO, plus of course your lawyer fees. And when you file there, you can delay your you can delay entering each country that you want by an additional 18 months. So the PCT gives you a total of 30 months from the earliest priority, but since you've waited 12 months, then you have 18 months remaining. And most startups like to pay that $5,000 for the PCT application in exchange for being able to defer that decision out by another year and a half for financing reasons or for sales reasons, for example. So along with this, you need to prioritize your key market and manufacturing location. And that's where the countries that you want to focus on filing your national, filing in the countries that you want to get patents in. So if China happens to be your major production hub, definitely file in China. If your customer base is in, let's say, France or Germany, you definitely want to consider a European patent. And so you need to account for different laws and requirements by country when you enter, and local counsel can help you with that. So make sure you ask the right questions for your international counsels. And that's how you optimize your international IP protection. Let's talk about how patents can significantly increase your valuation. So patents signal innovation and technological leadership to investors. When you acquire them, they are actually an asset that's going to be in your balance sheet. So you can certainly argue that your company value has increased by a certain amount by the IP. And that amount is certainly significantly more than the amount you spent on lawyers to file the patent application. So for example, you might spend $10,000 to prepare and file a patent application, but you can easily justify the asset that's procured by that as being worth $150,000 or $200,000. Investors will not push back on that. So you can see that spending $10,000 to get $200,000 of value, that's certainly a 20x gain. That's something that investors would be happy to get, right? So that's one component of increased valuation. The other component of increased valuation is that your exclusive rights can lead to higher profit margin, the bottom line, right? That's the EBITDA component. So if you can get an extra 5 to 10% increase in the profit margin, that ultimately translates to the EBITDA, and that ultimately is valued by investors over time. And so, they value a company by taking EBITDA divided by the interest rate, and that's basically the valuation of the company. So the higher the profit over time, your company would be valued more. So another advantage of a strong patent portfolio is that it can deter competitors. Competitors eat into your sales volume. And of course, if you have reduced sales, you're going to have reduced profit. And of course, that's negatively going to impact your company valuation. Conversely, if a strong patent portfolio can keep your exclusivity over the 20-year life, you're golden. The investors will love that increased value from increased sales that translates straight down into EBITDA, and then that will increase your company valuation. Patents can also open up license revenue streams for you, and this is free money, right? And investors will love any kind of increase to EBITDA based on licensing because that's just pure profit. Last but not least, IPs factor into acquisition valuations. Most acquirers want to see that the company that they're buying has a nice defensive moat, and IP is an important component of that moat. And so they will spend significant amount of time to perform due diligence on your IP portfolio. So make sure you have your IP portfolios polished and ready for a potential acquirer to review. And those factors, and that's how patents can significantly increase your company's valuation. Now we talk about common pitfalls new startups face. So first of all, one pitfall is to disclose inventions before filing patent application. Don't make the mistake of going off and talking to your vendor about what you're working on without an NDA and without filing patent application, because they can certainly take the idea and run. This is a common mistake made by people who advertise their technology on Kickstarter without any patent protection. You can just Google and find plenty of examples where companies run their campaign on Kickstarter, and when the campaign ends and they get the money from the buyers, lo and behold, they found a competitor already selling the product. So don't make that mistake. Second is many founders ask for confidentiality agreements from investors, and that's a novice mistake because investors will not sign it. So the stronger thing for you to do is to go ahead and file a patent application and confidently talk to your investor and say, hey, this is a patented concept. And that's all you need to say. They know what's going on. The second mistake is failing to secure IP rights from employees and contractors. Make sure in your employment agreement with employees that they assign all rights to the company. Same thing for contractors. Did you know that, let's say, if you hire somebody to design your website and you don't have a clause, a contract to assign all their work to you, all you have is a license. So if you did this for a contractor who designed your website, you would simply have a license to use it, but you don't own your website design. So make sure you have the rights to the ownership of all the IP rights arising from work products made by contractors or employees to you. So another problem is that they underestimate the importance of IP protection. I found this in the blockchain and fintech space, where many founders think, oh, I'm just going to open source my code. And I was thinking to myself, well, if you open source all your code, then what exactly is your competitive value? I can just simply take the code and then convert it into, and make some minor modification to it and compete against you. So many software founders, they love the concept of open source and they ignore IP protection at their peril. Another mistake that many founders make is not conduct freedom to operate searches. Many founders I talk to, they prefer to keep their head in the sand. And of course, what happened is you do all this work, you build up this nice market, and you don't search for patents that may block you. And lo and behold, when you reach a critical stage, i.e. you're beginning to have that hockey curve of your sales beginning to show the hockey curve effect of a unicorn, the big companies start knocking on your door, either requesting royalties if you're lucky, or they might want to shut you down. So perform your freedom to operate searches in advance and at least be aware of who might be coming your way so that you can either redesign your solution to avoid the patent, or you build up your own large war chest of patents as a negotiation ploy against those companies that may have blocking patents against you. So those are the common pitfalls new startups face. And if you have any question, please give us a call. Please visit us at patentpc.com.